Hi, everyone. Welcome to another episode of the Ask Amity Show. Today, we'd like to talk to you about transfer on death deed, TOD deed, and an update on the laws surrounding this transfer on death deed. So in 2016, California legislature created a revocable transfer on death deed, which we call as TOD deed, as a way for California residents to transfer residential property to named beneficiaries effective upon death. In 2021, the legislature passed SB 315 to update the law on TOD deeds and to address some problems in the earlier law and extended the law surrounding TOD deeds, which now will sunset on January 1st, 2032. Deeds that were executed before January 1st, 2022 are still valid, even if they differ from the additional requirements of the new law.
So some of the new requirements, the first thing is signing and recording. So a TOD deed is not effective unless the grantor signs and dates the deed before a notary public and two witnesses. Witnesses cannot be a beneficiary because it creates presumption that there was undue influence in creating the deed. Secondly, after the death of the grantor, the beneficiary must serve notice on the heirs of the grantor. The deed must be recorded 60 days or less from the time it is signed. And if more than one beneficiary is named in the TOD, the ownership interest must be divided equally.
Number two, if you are revoking a TOD deed, the new law allows 120 days after the death of the grantor to record a revocation. This means that the transfer that supposedly occurs at the time of death of the grantor is not finalized until up to 120 days later. And a TOD deed may be revoked by recording a new and different TOD deed, as the law allows more than one revocable TOD deed and provides that the effective deed will be the one which has the most recent recording date. A TOD deed may also be revoked by transferring the property to someone else by any type of legal valid deed and recording that deed prior to the transferor's death. Leaving the property to someone else in a will does not revoke the TOD deed.
So some reminders of the disadvantages to the TOD deeds. Number one, it can only be used to transfer 1 to 4 residential dwelling units or condominium units. A single family residence with less than 40 acres of agricultural land or a mobile home that is a fixture. Number two, it cannot be used to transfer residential property held as joint tenancy or as community property with rights of survivorship. It cannot be used to create split interests such as life estate. Number three, it cannot designate contingent beneficiaries. And number four, it offers no protection from the grantor's creditors. Therefore, the beneficiary may end up with nothing if the debts of the grantor are larger than the worth of the property. Additionally, because there may be unsatisfied creditors' claims against a property, some title companies are not willing to issue title insurance to the beneficiary until 3 years after the grantor's death. If you have any questions about transfer on death deed or you want to talk more about it, give us a call. We'll be more than happy to provide a free consultation. Until then, please subscribe to our channel and we'll see you in the next one.